Major breaking news, a huge Supreme Court argument involving whether or not Donald Trump has the legal authority under federal statutory law and under the United States Constitution to do his job using tariffs to negotiate and address what he considers to be economic and other emergencies to our great nation. What just happened and who's going to win and how does this all play out and what do you need to know about this fight at the U.S. Supreme Court and Donald Trump's tariff powers? We'll break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we need to talk about the Supreme Court oral argument involving whether or not President Donald Trump has the legal authority to use the economic weapon of tariffs on foreign countries to really get America a better deal and or to protect America from harm. Now, this is a complicated issue, but I'm going to break it down and make it quite easy for you. To begin with, what I'm going to do is I'm going to identify the big issues. I'm going to give you a couple general observations, and then we're going to talk about Donald Trump's arguments, and then I'm going to tell you how it's going to all play out, I suspect. To begin with, the overall question is really quite simple. Can the President of the United States, in this case Donald Trump, does he have the legal authority to pick up the phone and issue statements and declarations that identify specific foreign countries as being problematic actors, and then issue a tariff on goods and services coming in from those countries, using those tariffs as leverage, if you will, to negotiate better trade deals with those countries? That's the question. Does he have the legal authority? Now, to answer this question, there's really two levels of questions. The first question is there a congressional statute on the books, a federal law on the books passed by Congress that gives President Trump this power? Donald Trump argues that the law known as the International Emergency Economic Powers Act, or IEPA, gives him this power because the text of the statute says that if there's something highly unusual or extraordinary when it comes to really foreign-related issues, meaning foreign countries doing bad stuff or something like that, then, according to the statute's text, the president has the authority to regulate the importation of any property in which any foreign country or a national thereof has any interest by that person. The question is, does the phrase regulate importation in that statute include the authority of the president to issue tariffs or not? That's the first question. The second question is, who gets to decide what is an emergency? Because the IEPA, the federal statute passed by Congress in the 1970s, says that there has to be an emergency declared by the president in consultation with the Congress. The president declares the emergency, identifies the emergency, issues a proclamation, and then once that occurs, he has that legal authority under the statute to regulate the importation of goods and services and property from foreign nationals and from foreign countries. So who gets to decide what's an emergency? The third one is any of this constitutional? And what I mean by that, and this is a big deal, folks, and listen carefully, we're going to be a little nuanced here, but you're going to understand it. It's true that Congress enacted the statute IEPA, the International Emergency Economic Powers Act, to give the president powers to step up and deal with foreign nations. But the question becomes, and this is a big deal, and this is really the second legal question, is even if the Supreme Court agrees with Donald Trump's interpretation of IEPA, the federal statute, and even if the Supreme Court says, yeah, we agree that the phrase in IEPA that says that the president has the power to regulate the importation of property belonging to foreign nations or to foreign nationals, even if we assume that does include the power to engage in tariffs or to issue tariffs, the question is that statute here, as applied by President Trump, constitutional under Article 1 of the United States Constitution? Just to jog your memory, Article 1 of the Constitution creates our legislative branch and outlines the powers of Congress. Article 2, the powers of the presidency. Article 3, of course, creates the Supreme Court and the courts. You see, under Article 1 of the United States Constitution, it specifically says that all legislative powers granted in Article 1 of the U.S. Constitution shall be vested in the Congress of the United States, including the Senate and the House. And as part of Article 1, and listen carefully, this is the key, it says that Congress shall have the power, under Article 1 of the United States Constitution, the highest law of the land, Congress shall have the power to, quote, to regulate commerce with foreign nations, including the several states and with Indian tribes. Now, the reason why that is critical is, as you know, if that federal statute, IEPA, that Congress passed, that gave authority to Donald Trump to regulate the importation of foreign goods, includes the power to tariff. Assuming all that is true and statutorily Trump has that authority and the Supreme Court agrees, even assuming that's all true, folks, the Supreme Court is curious or asking the question whether that statute, in this case, is unconstitutional. Because under Article 1, the Congress has the authority as a constitutional matter to regulate the commerce with foreign nations. And there is a doctrine that arose really, well, it's been around for quite some time. I think the last time it was really deployed robustly was in the 1930s. I think you can have a debate about that. But the doctrine is known, listen carefully, as the non-delegation doctrine. And under the non-delegation doctrine, it's a theory by the Supreme Court that says that Congress does not have the constitutional authority to delegate its core essential authority under the Constitution to someone else. And what does that mean, Mark? Here's what it means. Think about this for one moment. Because Article 1 of the Constitution says that all legislative powers in Article 1 belong to the Congress, they are vested in the Congress. Under the non-delegation constitutional doctrine, that means Congress cannot, let's say, tomorrow pass a law that says, going forward, all federal gun laws shall be decided upon and determined by Mark Smith and the Four Boxes Diner. Like, Congress could pass that law, right? They could pass a law that says, we have concluded that we are going to give away all of our legislative powers under Article 1 of the Constitution to Mark Smith and the Four Boxes Diner to make all decisions about what federal gun laws will be on the books and all the issues associated with firearms and so on and so on. Now, that would be unconstitutional for Congress to do that. Because under Article 1 of the U.S. Constitution, again, it specifically says that all legislative powers granted in Article 1 are to be vested in the Congress. And therefore, Congress is not permitted to delegate it, or i.e. give away that authority to either Mark Smith at the Four Boxes Diner or to anyone else, including but not limited to the president. So too, Congress could not pass a law that says we're going to give away all of our legal authority under Article 1 of the U.S. Constitution to determine the tax rates and everything there is to know about taxes in America to the president. That is also unconstitutional. And the reason why Congress cannot delegate its inherent authority under Article 1 of the Constitution to Mark Smith and the Four Boxes Diner, and it cannot delegate that authority to the President of the United States, is known as the non-delegation doctrine, that says that because the powers are vested in Congress, they're not legally allowed to, under the Constitution, delegate those authorities or powers to someone else. So here, when it comes to the tariff fight, The first fight is, what does the statute mean in terms of regulate the importation, and does that include tariffs, which President Trump says it does include tariffs. The anti-Trumpers say it does not include tariffs. And then even assume it includes tariffs and Donald Trump is acting legally under the federal statute, the second question is that statute constitutional in light of the fact that Article 1 of the Constitution, the highest law of the land, which is above the statute, says that you can't delegate, or Congress has to deal with the commerce and the regulation of commerce with foreign nations. Those are the two issues. Now, let's start talking and breaking this down a little bit. It is pretty clear from the questions presented at the oral argument, as I see it, that the phrase regulate importation or regulate the importation of property will include tariffs. And a big reason why this is the case is because of some questions that Justice Brett Kavanaugh asked about what's known as the 1917. Hey, I warned you guys, this is geeky. Turn in the 4 boxes down, or you're going to get this geek stuff sometimes. I'm sorry. It just has to be done. But you'll understand it when I'm done. Justice Kavanaugh and others pointed out, as did John Sauer, the Solicitor General for Donald Trump, who argued this case for Trump, that under the 1917 law known as the Trading with the Enemy Act, that was the precursor statute to IEEPA. From 1917 until the 1970s, the relevant statute was called the Trading with the Enemy Act, that gave the president the authority to act in foreign affairs when it comes to economic issues if there's an emergency or a war and the like. I won't bore you with all the details about that, but that's the essence of it. And then after a currency crisis in the early 70s, where, and this is key, listen carefully, folks. In the early 1970s, President Richard Nixon imposed tariffs on foreign countries because of a US dollar currency concern and emergency. And President Richard Nixon used the 1917 law, Trading with the Enemies Act, to deploy and use tariffs. I think we applied 10% tariffs around the globe in 1971 under the Trading with the Enemies Act. Now, after that, Congress got rid of the Trading with the Enemies Act, but they replaced it. Hear what I just said? They substituted the Trading with the Enemies Act with a broader statute known as the International Economic or International Emergency Economic Powers Act, i.e. IEEPA. So during the argument, Brett Kavanaugh and others are pointing out, hey, you say that regulating in the importation of goods does not include tariffs, but the precursor statute, the statute that the IEEPA statute sort of grew out of, the Trading with the Enemies Act, Richard Nixon in 1971 literally used tariffs, and that was upheld. And therefore, since this is the successor statute to the Trading with the Enemies Act, which allowed for tariffs, obviously you get to allow for tariffs here. That's a pretty strong point as a matter of statutory interpretation. And I think it's likely going to prevail that regulating the importation of goods would include tariffs, because keep in mind, I believe under the law, it actually allows the president to stop trade. So if you can stop trade, you certainly can tax it in the form of tariffs. Now, the second thing that pops up is, and this is in the literature by the typical mainstream media, that there's something known as the major questions doctrine that was used in part to stop, and listen carefully, to stop Joe Biden from, for example, not forgiving student loans. He tried to forgive all these billions of dollars in student loans, and the Supreme Court said no can do. And part of that was what's known as the major questions doctrine. But all you need to know for our purposes with the tariffs is this, that the major question doctrine, which says that if there's a major question dealing with an ambiguity of a statute, then basically Congress has to step in and clarify it. The courts will not allow the president to go off and do whatever it wants. But here's the key. During the oral argument, Supreme Court Chief Justice John Roberts pointed out that the issue with the Biden student loan forgiveness reason, why it was unconstitutional and illegal for Joe Biden to use his executive authority to forgive student loans, and why that's different than the tariffs, is because the Joe Biden issue involving the student loans was entirely domestic. It was all about domestic affairs in the United States. In contrast, the tariff issue involves foreign policy. And when it comes to foreign policy and negotiating with foreign countries and protecting our country from foreign adversaries, it is 100% the case that Article 2 and the President of the United States, and Article 2 that gives the President his authority, the core central function of the President of the United States and the executive branch is to protect us from foreign invasion and to handle foreign adversaries and foreign issues. So Chief Justice John Roberts is basically like, well, the major questions doctrine, which we used in part to knock out a bunch of Joe Biden stuff, that was all about domestic affairs in America. It had nothing to do with foreign policy. And when Chief Justice John Roberts during this argument says, well, all these issues are foreign facing, meaning President Trump is using these tariffs to negotiate on behalf of America, trade deals and the like, that is a different animal than what Joe Biden was doing, which had nothing to do with foreign affairs or shutting down China and Mexico and Canada from their misbehavior. And that is what Donald Trump is doing. So I think there's a very strong argument that because Donald Trump as the president gets to deal with all foreign affairs and protect us, it is much different than what Joe Biden was doing during his presidency. So with all that said, what is going to happen? I don't know. This is going to be a close call, but I will say this, that there's a lot of reporting that the Trump lawyer, John Sauer, was getting a lot of tough questions, but that doesn't mean he's going to lose, because it is often the case the Supreme Court justices ask lawyers really tough questions, the lawyers that are representing the side they're going to agree with, because they want to hear the best possible answers to criticisms. So when those justices write the opinion, they have the best answers to rebut, for example, what Ketanji Brown Jackson, Supreme Court Justice, might have to say in her dissent. So a lot of times you're asking tough questions of the lawyers who you agree with to get the best possible rebuttal to what you expect that you're going to have to deal with when you write that opinion. So in short, I think there's an excellent chance that Donald Trump is going to eke out a win here. It's going to be very close. There's a lot going on here, and the two main reasons why I think Trump's going to win this, I think, is because, number one, the Roberts Court has been very deferential to presidential powers as a general matter, not just for President Trump, but all up and down the line for many years. And number two is this really is a foreign policy issue that goes to the core function of the executive branch and the presidency, which is about protecting America against foreign adversaries and dealing with foreign affairs. And I find it very difficult to see a situation where the Supreme Court is going to take away this critical foreign policy tool from the president in light of the fact you have this statute in place, and the predecessor statute actually allowed for tariffs, although that statute, the Trading with the Enemy statute from 1917, did not mention the word tariffs either, but tariffs were allowed in 1971 when Richard Nixon did it, and there was no complaint there. That was upheld, and I suspect that we're going to see a similar outcome here. And as to the non-delegation doctrine argument, I think it's a very interesting one, but I suspect the court will say that there's enough guidance by the Congress to the president to sort of rope him in. And because this is foreign-facing related issues that goes to the core of what the White House and the presidency does, I think there's a good chance the Supreme Court's going to say, you know what, we're going to let this one alone. This is like a political question for the political branches and we the people to fight it out if there's a debate about this. But we are not going to shut down a major foreign policy activities or major foreign policy activities of the President of the United States with dealing with China, Mexico, and all these other countries. I think there's a good chance that's going to be the outcome. But again, the history of the future is yet to be written. All right, folks, hope that was helpful. Make sure you follow me on X at 4boxesdown. Don't forget to subscribe to YouTube and Rumble. And I'll talk to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.